and attendees, trustees, principal officers, colleagues. For those of you who don't know me, I'm Zareena Camroodien. I'm the HOD of Fund Governance and Trustee Conduct within the Retirement Fund Supervision Division. And as indicated, we will be taking you through the disposition of death benefits during this session. The areas that I will cover in respect of the death benefits will be, of course, the section that regulates the payment of death benefits, which is section 37C. Importantly, who qualifies as dependents? As you may know, that in the context of death benefits in terms of section 37C, it's a very wide range of dependents. Of course, of paramount importance is that the death benefit distribution must be done equitably, and therefore we will be covering equitable distribution considerations, the purpose of a nomination form. That is also quite important, and it has come under scrutiny recently in terms of, what is the purpose, of what force or what weight should be given to a nomination form. And then we will end with the methods of payment of a death benefit. I think that those of you who have attended, before I start, for those of you who have attended the previous session, so I will be going through the presentation, as will the other presenters, but as we go along, you're welcome to type in questions in the chat. But also, please, we would like to have quite an interactive session. So if you have any questions, please, after the session, please feel free to raise your hand and ask the questions. Where we have answers, we'll give them to you. Where we don't have, we will revert, because there will be a consolidated Q&A together with the presentations that will be sent to you after the last day of the Trustee Toolkit training. Moving on to section 37C, as we said, when is a benefit subject to this section of the Pension Funds Act? So section 37C of the Pension Funds Act regulates the payment of lump sum benefits payable upon the death of a member of a retirement fund. And usually what is required is that member must have been an active member up to the date of his death. So 37C would generally not be applicable to members who have already left the service of an employer. I know that there are exceptions, and that's why one has to have regard to the rules, but generally, as I said, the death benefits are payable in terms of section 37C at the date of the death of the member who is in service. The death benefit is calculated, as with many other benefits, in terms of the rules of the fund. And it comprises, and I think Zakir Inus, when he touched on the types of benefits, he also indicated this, that it comprises the deceased member's fund credit at the time of his death, and where applicable, and that's really the case in most cases, it also comprises an insured portion of the risk benefit, which is usually made up of a multiple of the deceased member's annual pensionable salary. The object of section 37C. So section 37C1 provides that notwithstanding the provisions of any other law and the rules of the registered fund, any benefit, of course subject to certain exceptions, which I have in the presentation, payable upon the death of a member must be dealt with in terms of the scheme outlined in section 37C. So the legislature has adopted a very broad definition of a dependent, as I intimated earlier, and has favored dependents over nominees in death benefit distributions. And maybe we'll pause there. The reason for this is that death benefits or the purpose, it also has a, apart from it's payable in terms of the rules, it has a social policy underpin. So it is there to ensure that that the persons who was dependent on the deceased at the time of his or her death are not left in a financially precarious position and do not become a burden to the state. So that is really the social policy underpin, which is quite important in the context of Section 37C. As I said, this is possibly a new point, a death benefit of the member generally does not form part of the member's estate, as that was earlier on. But of course, there are exceptional instances which are mentioned in Section 37C. So it generally doesn't form part of the member's estate because really you'd be paying your dependents, you'd be paying your nominees. But the exceptions one would find in Section 37CB and C of the Pension Funds Act. So 37CB basically says where your aggregate of liabilities of the deceased member's estate exceeds the assets and there are no dependents, but there are merely nominees, then the deficit will be covered by the death benefit and the balance will then be paid to the nominee in terms of the nomination form. However, what Section 37CC provides is that where there are no dependents and there are no nominees, then the benefit will be paid into the member's estate. And that just shows you how important it is, your job as trustees to firstly find the dependents of the member and also to be able to identify the dependents, the nominees. So make sure that you have the nominees because really, of course, the last resort is the payment into the member's estate. Now, with the enactment of the default regulations, 37, 38, and 39, the scope of application of Section 37C has been extended to your deferred pensioners or paid up members and your deferred retirees. This was made clear in our interpretation, the FSCA's interpretation ruling 1 of 2020 on retirement funds, on the interpretation and application of 37C. However, if you now look at, if you have had sight of the consequential amendments to COFI, to the Pension Funds Act, there are changes that are afoot, which will basically provide that where a deceased member is a pensioner who is in receipt of a living annuity or a life annuity, where payments are guaranteed to continue for a specified period and the pensioner dies within this period, the retirement fund must then pay the pensioners nominated the person that the pensioner had nominated, the nominated beneficiaries. So as you see that there has been a shift from the interpretations ruling 1, which says that 37C would be applicable. So you see that the nominee would then be paid where the pensioner has in fact nominated such persons. Again, it really illustrates the importance of nominating people as well to receive your benefits. When the pensioner has not nominated any beneficiary, then the payment will actually also be made into that pensioner member's estate. And of course, if there is, if not the estate, it will be paid into the guardian's fund or an unclaimed benefit fund. The duties placed on the Board of Management in terms of Section 37C, that's very critical. And as you are probably, most of you ought to be au fait with this, particularly the seasoned trustees, the new trustees. There are important duties placed on the board to distribute a death benefit. And the main duties are really the three duties. It's basically to identify the dependents and nominees of a deceased member, to effect a distribution amongst the beneficiaries, an equitable distribution amongst the beneficiaries in accordance with the provisions of Section 37C, and to determine an appropriate mode of payment. Who qualifies as dependents? As I said, this is such a critical question in the context of Section 37C. So if dependents are to be correctly identified and successfully traced, the process must start with a proper construction of the definition of a dependent under the Pension Funds Act. Now, Section 1 of the Pension Funds Act defines a dependent as follows. A person in respect of whom the member is legally liable for maintenance. B, a person in respect of whom the member is not legally liable for maintenance, but if such person was, in the opinion of the board, upon the death of the member, factually dependent on the member for maintenance. So that is your B1 dependence. Is the spouse of the member as defined. And I'll pause here too, because you may see that there is an overlap with your legal dependents as the paragraph A dependents and your paragraph B2 dependents, because spouse, as you may know, is defined as a spouse of, in terms of the Marriage Act, the Recognition of Customary Marriages Act, the Civil Union Act, and the tenets of a religion, as well as cohabitees in the Pension Funds Act. Paragraph B3 defines a dependent as a child of the member. That includes a posthumous child, an adopted child, and a child born out of wedlock. And of course, I think some of these terms might seem a bit antiquated because, you know, child out of wedlock, but of course there's a history attached to it because, you know, very many years ago, of course, these things were viewed quite differently. And I think that's why it was expressly provided for in the Pension Funds Act. You may also say that, you know, the nascitudinis fiction already takes care of the posthumous child. Again, you know, there's a context to why it was included, and it was just made absolutely abundantly clear out of abundant caution. The definition, you know, of dependence captures the wide array of children, as well as the child of the member. That, of course, would include an adult independent child. Also, a person in respect of whom the member would have, that's your category C, have become legally liable for maintenance had the member not died. We shall now deal with each category in turn. So your category or your paragraph A dependence, your legal dependence, it's a person in respect, as I indicated, of whom the member is legally liable for maintenance. So a legal duty on one person to maintain another arises when three requirements are met. Firstly, the relationship between the parties must be such that the law imposes a duty of support. Secondly, the person claiming maintenance must be unable to support him or herself, and the person called upon to provide support must, of course, have the necessary means to maintain the claimant. A child maintenance court order automatically fulfills the above requirements and deems the child a dependent of the member. It is therefore important that the board should use these maintenance orders to identify dependents, and they should also thoroughly examine the maintenance orders to ensure that the children are dependents. In the absence of a child maintenance order, An ex lege or by law duty is imposed on the member to maintain a member's children. Of course, we know that all parents have a legal duty to support their children. Of course, if the member has the means to maintain the children and the children are in need of the assistance. Of course, you have your death benefit. So chances are that to some extent you will have the means to maintain the children. A member's duty to maintain the member's children does not come to an end when the children reach the age of majority. So this idea that when the children reach the age of 18, that is when your duty to maintain the child stops, that of course is erroneous, because it only ceases when the children become self-supporting. Because let's face it, or at least from my experience, just because someone is 18 years of age, in fact, many kids are only in matric at that age, so they are certainly not in a position to maintain themselves. Then they might be studying, they might be working, but not earning enough to really support themselves. So you'll still have a duty to maintain that child who is a major but not self-supporting. The
Sorry,
age of
Zareena.
majority.
Sorry,
Sorry.
sorry to interrupt you before you proceed. I think Patrick had his hand up. Perhaps there's a matter that you would want to take care of quickly before you proceed. From Patrick.
Okay.
Not sure if his hand is now down. I'm not sure if he got discouraged, or perhaps we'll take his hand right at the end. Then, if he's not, if Sancha could just unmute his mic, perhaps.
Hi, Tando. If Patrick could raise his hand again, then I can find him and enable his mic.
Okay.
I think perhaps it's best to take questions at the end so that we can get through Zareena's presentation. Okay.
All right. Thank you. Sorry, Zareena, proceed, please. All right.
Okay, no problem. If Patrick did feel that the question was pressing, I really don't mind taking a Tando and Sancha, unless you feel differently.
No, by all means. And I thought perhaps it was relevant to the topic that you were on at the time. So that's why I thought perhaps it couldn't wait. But I don't see him raising it up again. So perhaps in the end he will try, and Sancha will enable his mic. Sorry.
Yeah. Okay, but Tando, I'm quite flexible. As long as it doesn't take too much time. I'm quite flexible if participants would like to ask questions. Whilst I'm busy with the presentation, that's also fine. But let me continue. So as I said, the age of majority, and many of you will know this, I mean, especially those of us who are a bit older, the 21sts, the many 21sts that were held, to signal that age of majority and all sorts of things that you were now legally able to do. That was changed to the age of 18 years with effect from 1 July 2007. And there's case law that, of course, supports that this legislation is prospective in nature and not retrospective, as in the cases of most legislation, unless it's expressly provided for otherwise. If the identified children of the member meet the requirements, they are deemed to be dependents, and the board of the retirement fund must consider them in the distribution of the member's death benefit. The failure by the boards to take every reasonable step in identifying potential maintenance liabilities may result in damages being awarded against the fund. And this, of course, is important because we do find that boards sometimes don't find all the dependents that they ought to have found. And, then after a distribution has been made, they may come forward and say, but why was I not considered? I'm also a child of the deceased, or I'm also a wife of the deceased. I'm also a partner of the deceased, and I was dependent on him, to sustain myself. So in that context, then of course, if the board hasn't taken all reasonable steps to identify the dependents, this may result in damages being awarded against the fund. Turning now to your paragraph B1, de facto dependence. De facto means factual dependence. A person in respect of whom the member is not legally liable for maintenance, but the person was in fact dependent on the member for maintenance as determined by the board. So this is an important one because, of course, this is sort of out of the ordinary if you look at the laws, in South Africa generally, because generally one would look at legal dependency, but as I said, in the scheme and in the context of pension funds, we also look at factual dependence. So Section 1B1 of the Pension Funds Act requires that the board of the retirement fund must determine whether a person is a factual dependent. And how do you do this? You do this by examining the type of support that the member had afforded that person. If the board is of the opinion that the person is a factual dependent, the board may consider the factual dependent in the death benefit distribution. This, of course, doesn't mean that the factual dependent is automatically entitled to be considered in the death benefit distribution or that he or she will receive a portion of the death benefit. The board, of course, must use its discretion when determining the equitable distribution of a member's benefit. It's also important to note that with factual dependence, it can't merely be, once-off payments or irregular payments that really that establishes that factual dependency. Irregular payments don't necessarily indicate a maintenance relationship between the factual dependent and the deceased member. A clear distinction should be made between maintenance, which is regular payments, and generosity, irregular payments. So if you felt very kind to give people certain sums of money, it doesn't follow that they would be considered, a dependent of the member. So, but also moving back to the second point on the slide is that although the term maintenance is not defined in the Pension Funds Act, the scope and the extent of the maintenance is wide and does not only represent the bare minimum of a dependent's basic needs. If we look at Gunpath versus Momentum Funds at Work and another Financial Services Tribunal case of 2019, which speaks to the regular payments, it provides that constant and regular payments made by the deceased member would normally suffice to support a claim of dependency. The board of the retirement fund should use its discretion in determining if the payments are sufficient to confirm a maintenance relationship. So, of course, I think that what would happen in the normal course, funds would look at, as I said, the maintenance court orders, but it would also look at, are they for example, your bank statements, are regular payments being made to certain persons, in what amounts, or even if people come forward and say, but as sometimes happens, and where they say, oh, I was also a dependent, I received X, Y, and Z amounts, and then that person may also be asked, can you provide proof that these amounts were received on a regular basis? Moving now to the paragraph B2, or the spouse as defined. As I said, the section specifically tries to cover a person in respect of whom the member is not legally liable for maintenance and therefore excludes civil marriages from which a legal liability arises. In this section, a spouse is considered a dependent of the member, even if the spouse is not financially dependent on the member. But as I said, this is spouse as defined, because as you may see, there is an overlap between your paragraph A dependents and your paragraph B2 dependents. But when in fact section 37C, as you know, section 37C will be overhauled more comprehensively in due course, in respect of which you all will have be given an opportunity to comment thereon. There will be some alignment because, of course, the paragraph A dependence covers your civil marriages. It now covers your Recognition of Customary Marriages Act. It covers your Civil Union Act, even to some extent the tenets of a religion. So there's a bit of overlap, but that will be ironed out when we do the overhaul of the section. The section will also specifically covers permanent life partners, cohabitees, where the member and the person live together as spouses without necessarily, of course, observing the formalities of a legal marriage. And that's important because, in fact, in the South African context, as you may know, there are many people who choose not to do a formal marriage. They prefer cohabiting or having a permanent life partner for an array of reasons. And it's so that these dependents are also not left in an invidious position once that member dies, in terms of not having the necessary support that they may require. Turning now to your paragraph B3, dependent children, which I've touched on as well. This section specifically covers children of members, and as I had indicated, it includes financially independent adult children, posthumous children, as I said, that would also have been covered under the Nasci jurisdiction, but there's express mention of that. Then adopted children and children born out of wedlock. And as I said, many of these categories are probably, it stems from our history, where, children, for example, who are born out of wedlock, some very conservative view was that such children shouldn't inherit. The same may be applicable to adopted children, etc. So, those antiquated, obviously, views are out of the window, thankfully. But I think that here they just wanted to make sure, again, that as wide a range of dependent children are covered as possible. Then dealing with paragraph C, dependents, a person in respect of a member of whom a member would have become legally liable for maintenance had the member not died. So this is really in the event that the deceased died before, again, the birth of his or her child. It follows that the normal legal duty of support for one's child arises. Had the child not died, of course, she or he would have been liable for the maintenance of his or her child. So that basically this paragraph C, dependence, caters for that situation. It also caters for the situation where, where dependents who fall in the category are the parents of the deceased, for example. As you know, there's a common law reciprocal duty of support for one's parents. But that, of course, is conditional upon the deceased having been able to provide the support to his or her parents, and the latter being in need thereof. The test with parents, as you may know, is generally one of indigence, but in this context, it also includes, it's not maybe as high a threshold. There's also authority that the need of the parents would be sufficient to actually make that parent have that dependence on the child. So that would be sufficient, the sufficient threshold to be met for a parent, for example, to also be a dependent in terms of Section 37C of the Act. Moving now to the equitable distribution considerations. What must be considered to ensure an equitable distribution? So as you know, after the dependents, firstly, you have to identify your dependents, and after they've been successfully identified and traced, the board has 12 months within which to distribute the benefit to the dependents so identified. If, however, after the lapse of the 12 months, the board does not become aware of any dependents, the benefit will then be paid to a nominee designated in writing. That's important. The nominee must be in writing by the deceased, provided, as I said, where the liabilities in the deceased, then the benefit has to be used to settle the deficit, and then the balance is paid to the nominee. Also, that 12 months, you know, it's not cast in stone. So there are instances where the board may, in exceptional circumstances, make the payment outside of that 12-month period. But in any event, you have to identify and successfully trace the dependents within that 12-month period. Moving on now to Section 37 CBA, it provides that if a member has dependents and has also designated in writing a nominee to receive the benefit, the fund shall, within 12 months of the death of the member, pay the benefit or a portion of such benefits and or nominees in proportions that the board may deem equitable. So you'll take your basket of dependents, you'll take your nominees, to put it differently, and then you'll make an equitable distribution, you know, between the dependents and nominees. The Pension Funds Act doesn't recognize a hierarchy of dependents, and it's very important that the board exercises its unfettered discretion. Having said that, the adjudicator has formulated a test comprising factors the board must have regard to when distributing a death benefit. So although the determinations of the adjudicator, as we know, are not binding, the test is instructive in this regard. As many of you know, the test was formulated in the case of Sitole, where the adjudicator held that the board must consider the following factors when making an equitable distribution to the dependents. The board must look at the age of the dependents, future earning capacity of the dependents, the wishes of the deceased, the relationship between the dependents and the deceased, and the financial status of the dependents, and of course, the amount available for distribution. Each criterion will be explained briefly. So the age of the dependents, of course, the age of the dependent is relevant when viewed against that of other dependents with a view to establishing the number of years during which the dependent may still be in need of maintenance. So if you have a dependent who is, for example, 2 years old, they won't have the same needs as an 18-year-old, of course, because the dependent will have a longer dependency span on the deceased. So take a real life example. If I have a couple of children, which I do, my youngest child, say my youngest child is 2, will definitely not, you know, necessarily receive the same benefit that the one who is 18, who is at university, etc., receives, or who is independent. So moving on from the age of the dependents, but that is an important factor as well. You look at the future earning capacity and potential of the dependents. So the potential earning capacity of the dependent is a useful consideration in determining whether or not the dependent may be allocated a benefit, and if so, how much. Of course, for example, if someone is educated, if they're skilled, those are important factors and an important indicator in assessing each one's earning potential. Then, of course, the wishes of the deceased are an important consideration when viewed in conjunction with other factors. You don't just merely, ignore the wishes of the deceased. Further to that, the relationship of the dependents with the deceased. If I may just pause at this point, I'm so sorry. I just have to, I will be, okay, maybe let me just continue. Okay, so then the relationship of dependents with the deceased. The relationship of the dependent with the deceased is an important consideration where, for instance, the deceased and the dependent were still legally married at the time of the deceased member's death, but had been living apart for a considerable amount of time. This may guide the trustees in determining whether and to what extent the death of the deceased may affect the dependent financially. The board must consider in circumstances where the deceased, for example, as we sometimes find this case, died of unnatural causes, where there was the involvement of the dependent. As you may know, die bloedige hand neemt geen erfenis. So where the person might have been involved in the death of the member, that person will not receive a portion of the death benefit. And as I said earlier, if, for example, the parties were not living together, they were estranged, whether it's a spouse, whether it's children, that relationship that between the dependent and the deceased is also an important consideration. Then, of course, the financial status of the dependents is also an important consideration. This includes, in the case of a minor, the financial status of his or her surviving parent. So, for example, if the surviving parent may have a young, for example, it may have a young child that still requires support, but the surviving parent might be a professional, successful professional, then of course that also is a consideration, that has a bearing on what allocation and distribution will be made to that minor child. In respect of major dependents, financial means are also an important consideration, of course, viewed against the totality of other factors. Then last but not least, the amount available for distribution is also an important consideration, because although all potential beneficiaries may well be deserving of an allocation, having regard to other factors as outlined above, the amount available for distributions may sometimes determine whether an allocation will in fact be made. It stands to reason that where the amount available for distribution is large, the trustees have a wider discretion to allocate a large pool to a large pool of dependents and nominees. And of course, the converse applies. So when you have a small benefit, and a large pool, of course, some people may even be left out of in respect of the equitable consideration. The board has to perform a balancing act in considering the factors that have been outlined and on a cumulative basis. So it's not as if you nitpick certain factors and ignore others. It has to be on a cumulative basis without, as I said, placing overemphasis on any single criterion. In Sithole, the adjudicator said that the test is not whether the most equitable distribution was made, but the board must show that it has applied its mind by considering relevant factors and ignoring irrelevant factors. So, and contrary to the position under section 37(1)(b), where the board has no discretion if a dependent is not identified and there is a designated nominee, the board has a discretion under section 37(c)(b)(a) as to whether or not a nominee may be allocated any portion of the benefit. Turning now to the purpose of a nomination form. What is the purpose of a nomination form? A benefit payable on the death of a member is specifically excluded, as we said, from the deceased estate. It follows that ordinary testamentary laws applicable to the deceased estates doesn't apply to death benefits. However, that doesn't mean that the wishes of the deceased member are inconsequential. Section 37C1BBA therefore makes provision for the deceased to designate in writing, as I said, that's important, a nominee or more to receive the death benefit in proportions the deceased may stipulate. If we may also pause here, so the nominee as defined in the Pension Funds Act, that will also be clarified in the consequential amendments to COFI. It just merely, I think, makes clear what everyone already knows currently, that the nominee is a natural person and a nominee is distinguishable from dependent. So a nominee would not be a dependent. So I think what has been considered trite law will now be clarified in the legislation. The wishes of the deceased must be considered amongst the factors to which the board must have regard. The only means by which the wishes of the deceased are made known to the board, as I said, is by way of a nomination form. In Mashazi, the court found that a nomination form is merely a guide and has no binding force on the board. If you compare Mashazi, you'll also see the recent case of Swart and others versus Lukhaimani and others, where the court stated at paragraph 32 that although it accepted that the fund is not bound by the wishes of the deceased, the wish expressed in a nomination form is not to be lightly ignored. It said that it is one of the factors to be taken into account, but it is a substantial factor. Therefore, before the fund decided to ignore the nomination in that case, it should have considered whether there were compelling reasons to do so. The court said further it would result in an injustice or be inequitable should the deceased wishes be given effect to, then the fund would be justified in deviating from the deceased wishes. Here, the court said there was no evidence that the fund placed any weight at all on the nomination form. The question also arises, when do you determine dependency? This subsection requires the beneficiary to be dependent on the member for maintenance, where such dependency is as a result of a legal obligation at common law statute. The section doesn't expressly outline whether you qualify as a to qualify as a dependent, such dependent for maintenance must be as at the date of death of the member or the date of the fund, when the fund makes its decision to distribute the benefit. This issue arose in the matter of Guaniri, and the court held that the decision has to be made at the time of the distribution of the benefit and not as at the date of death. Moving now to the modes of payment. Having identified the dependents and your nominees and made an equitable distribution, the board has a duty to decide on the most appropriate mode of payment to the beneficiaries. Section 37C2 of the Pension Funds Act provides that for the purpose of this section, a payment by a registered fund for the benefit of a dependent or nominee contemplated in this section shall be deemed to be a payment to such dependent or nominee if it is made to a trustee contemplated in the Trust Property Control Act, nominated by either the member, a major dependent or nominee, subject to paragraph CC, or a person recognized in law or appointed by a court as the person responsible for managing the affairs or meeting the daily care needs of a minor dependent or nominee. So that would be your guardians, for example, or a major dependent or nominee not able to manage his or her affairs or meet his or her daily care needs. So that would be your curator ad litem or your curator bonus, as the case may be. A person recognized in law or appointed by a court as the person responsible for managing the affairs or meeting the daily needs. Care needs of a dependent or nominee or a beneficiary fund. No payments may be made in terms of this section on or after the 1st of January 2009 to a beneficiary fund which is not registered under this Act. The payment of a death benefit to a major dependent does not present many problems, as the dependent is generally capable of managing his or her own affairs. The major dependent may also, as you know, nominate a registered trust to which the benefit may be paid as an alternative to paying the benefit directly to the major beneficiary. In the ordinary course, the board must pay the benefit allocated to the major dependent in full in one installment. You know, you also, I mean, one of the matters that spring to mind, for example, is Moralo in the adjudicator's office. However, the said beneficiary has an election to receive the payment in several payments in terms of a written agreement, provided that the beneficiary may at any time terminate the agreement and receive the payment in full. Payment to a minor dependent, of course, though, is slightly more challenging. In the ordinary course, the board must pay the benefit to the legal guardian of the minor dependent. The powers to administer the affairs of the minor dependent are conferred on the guardian by operation of law. However, the board may form the view that the guardian will not fulfill his or her duties. There may be concerns, you know, that the guardian may utilize the monies for other purposes or not handle or doesn't have the ability to handle these monies, you know, to last for as long a time as the minor may require it for. In that instance, the board will have to show good grounds for its apprehension, if it has that apprehension. But if these good grounds exist, which it may very well exist, the board may pay the benefit to a beneficiary fund approved in terms of the Pension Funds Act, if payment is made on or after, and it would generally be the case now after 1 January 2009. The adjudicator's determinations militate against the practice of some boards in terms of which death benefits allocated to minor children are summarily paid into trust or beneficiary funds without trustees properly investigating whether the guardians of such minor dependents are capable of fulfilling their guardianship duties. But as I said, you don't fetter your discretion, but of course, if you're so minded in the equitable distribution and there are concerns that the money might be dissipated by the guardian, of course, by all means, the monies should be paid into a beneficiary fund. But of course, that is a decision for the board to make in the exercise of the equitable distribution. But I think that, you know, what the adjudicator may also be talking about in the determinations is the fact that, you know, some funds, I know some of them, you know, when the benefit is over X amount, so say the benefit is more than 20,000 or more than 50,000, they make a decision that, okay, no, then such benefit will then be paid into a beneficiary fund. You can't just make that decision. You must say, is the guardian capable of taking care of this minor child? You know, it's really, you have to have regard to all the factors and not just fetter your discretion in any respect, really. So that brings me to the end of the presentation. So if you have any questions, please feel free to ask them. Thank you very much.
Thank you, Zareena, for breaking down such a mammoth module. Sure, this is quite the popular module. We've received quite a few questions in the chat box, but Tando has been attending to them quite promptly. I see we have a hand. So Farid Ismail, I'm going to allow your mic if you can please unmute yourself.
Morning, can you hear me?
Yes, we can. Good morning.
Morning, thank you. Thank you, Zareena, for a brilliant presentation. I was a little bit late, so I'm not sure if you've covered this. Please forgive me for this question. It's twofold. When I joined, you mentioned that the benefit is based on the fund credit and any risk that may be accumulated as a fund benefit. My question is that if it's an unapproved insurance, would that still be considered a fund benefit? And does it still fall under this discretion of 37C for distribution? My second question related to that is that in some cases where employers make salary sacrifices for tax benefits and make contributions outside of the salary, where they give what we consider a gross salary and a risk salary, so where they can make a salary sacrifice to make these contributions, do then those life cover, what we term as GLA, group life assurance, become unapproved or approved? So sorry, that's my twofold question. I don't know if you've covered it. I was a little bit late.
No, Farid, that is fine. I think I tried covering it, but just going, actually the first one I didn't cover. So if it is that the benefit is unapproved, Farid, I think that was your first question. Then of course that would be regulated under the Insurance Act. But if it's approved, then that falls under the Pension Funds Act, and it falls for distribution in terms of Section 37C. So that is the one, to answer the one question, Farid. Then, of course, what comprises that, that risk benefit? It would be generally the multiple of the annual pensionable salary. So if it forms part of the pensionable salary, then it would be covered for the death benefit distribution purposes. Frida, I don't know if that covers you.
I'm still a little confused, sorry, in terms of trying to understand if the premiums paid over to the insurer, to the administrator for the pension fund, and if it's come off the salary before tax is being paid, would that be considered an approved or unapproved benefit? That's why I'm a little confused. So sorry about that question.
Okay, so if it is in the rules of the fund, Farid, then generally it would be an approved benefit. I think that would be the short answer. So if it's provided for in the rules of the fund, it would generally be an approved benefit.
Thank you. I think that gives me more clarity. Thank you so much.
Okay. And Farid, if you're still not clear, I will drop my email address in the chat, and then you're welcome to contact me. You're welcome to also contact Sansha or Tando. Thank you very much for your questions and your kind words on the presentation. Thank you.
Thank you.
Thank you, Farid. Next, I'm going to allow Emma's mic, Emma Munyanga, sorry. If you could please unmute yourself.
Okay, thank you very much for allowing me to pose the question, and thank you for the presentation. So I put this question in the chat box, and I was told to just pose it to the presenter. My question is, how do you settle a dispute over the paternity of a posthumous child? Maybe just to give a scenario, a member dies, there's a pregnant girlfriend who comes forward to submit a claim to the fund, but other family members then come and indicate that as far as they're concerned, the child is not the member's child, and they can give examples of why maybe the lady was with another gentleman, or I don't know. But then there is that dispute, and so now as trustees, we face with a situation where we have to make a determination whether we approve the claim from for the posthumous child. So it's a complicated situation, but I just wanted to find out what would you advise in that case? What would be the best way for the trustees to approach such a case? Thank you.
Thank you for that question, Emma. And I think this question does arise from time to time. So in this particular instance, if, for example, it is known that that person was with, as you said, the girlfriend, that they were in a relationship, then there's generally a presumption that that child that the girlfriend was pregnant with would be the child of the deceased member. However, Emma, I think your question is also a bit more, probably slightly more complex, because you're saying that there are allegations, and often it arises, even I suppose, even if it wasn't particularly the case, but that this person wasn't only the deceased member's girlfriend, she had another boyfriend or other boyfriends. As a last resort, Emma, as I said, as a last resort, you can resort to DNA testing, even though that is not your first port of call, because your first port of call is to establish, because generally, remember, if you're in a relationship with someone and that person is deceased, there is that presumption that that child is from the deceased, as I said. But if you have, and as a board, you think that, oh no, but you know what, you are concerned that this child may not very well be the deceased, as a last resort, as you know, you can still do a DNA test on the deceased body. Even though I think that will be considerably costly. And of course, there are all sorts of other concerns related to that. Thank you.
Zareena, if I may just add to what you're saying, I think I agree with you that the presumption of law is that you would be generally considered to be the father of a child when that child is born reasonably born within the period that you would have been with the person concerned. But then also the question of a paternity test. I think Emma raised the question about, or somebody else raised the question about, who is responsible for the paternity test if there's a dispute. My understanding is that there are constitutional issues, obviously, that would intervene when you want to test a child in terms of the medical procedure that is involved in doing paternity tests. So the child's mother may very well refuse to take the test. But as I understand it, there's a presumption again against the person who refuses unreasonably, that they may have something to hide. So on the question as to who pays for the paternity test, I think the person who is alleging or disputing the paternity should be the one paying if the mother consents to the paternity test. And obviously, with the presumption, negative inference being drawn from her refusal to accede to the request for the paternity. Thanks, Zareena.
Yeah, sorry, just so Tando, I think I agree with you, but the fund will have to pay for that test, eh? I think that is it would only be fair for the fund to pay for that test. I see that there are quite a few. Sorry, I'm trying to go through some of the questions now. I'm just trying to work through the questions where it may not have been answered, but please, I'm also more welcome hands. But just going back to that, so Tando, thank you for elaborating for Emma. But as I said, look, the fund would have to pay for the test, of course, unless the rules provide otherwise. So if your rules say that, someone else has to pay for that test, then so be it. But the fund would generally have to pay for that test. I think there was also, sorry, I'm also just scrolling through the questions. There was a question on, but what if the kid or the children or a child just stays at home, but they have the ability to earn. So in respect of that question, look, as I said, the fund must have regard to the basket of factors. So it's not just the child putting up their hand, saying, just deciding to stay at home. You will look at, does that child have earning capacity? So is it just a laziness issue? But I mean, it could be an array of issues, you know. I mean, in the South African context, there's such a high level of unemployment. So even if the child might be at home, it could be not, it's not merely laziness, but inability to find work. But as I said, you really have to look at the cumulative factors. We don't just, that's why we don't just pull out one factor. But I see another hand. Tando, are you helping with the hands?
Hi, Zareena. The next hand is from Tersha. I'm just allowing her mic. Tersha, if you can unmute yourself, please.
Yes, hi, good morning, and thank you kindly for the presentation. My question is, it is on the chat box, but I wanted to just say it now. I just want to know if there is a nominee that predeceased the deceased, or maybe they passed away before distribution. What is the law in terms of that? Is it redistributed to the remaining beneficiaries, or in the case of nominees, is it redistributed to the remaining nominees? What is the actual law on that one?
Okay, so where the nominee, if I understand you correctly, Tersha, where the nominee predeceases, you're saying where the nominee predeceases the deceased.
Yes, yes.
Yes. So, you know, as Guaniri says, that death benefit distribution, or that consideration of the dependents and nominees, must be made at the date that you actually, not even that the deceased dies, it's when you make that distribution. So certainly that nominee will then not be considered. And to answer the latter part of your question, it won't be, it will then fall back into the distribution pool, but it won't necessarily go to the other nominees. Because remember, a nominee is generally nominated for a portion of the benefit. So it doesn't mean, so say someone was given, say you have two nominees, hypothetically, your friend and your cousin.
Mhm.
And your, you know, and let's just say the friend dies, it doesn't, or the cousin dies, you know, it doesn't mean that the other nominee will now get 100%. It just goes back into that pool for distribution. Tisha, I hope that answers your question.
Yes, it goes back. Then we've got only two nominees, and the one has passed on. We are left with one nominee. So we put it back, and how do we redistribute it? The estate is solvent, and we've got this 100% money with one nominee now. Do we give it 100% to that nominee?
No, you'll still have to look at your dependents. Are there no dependents?
No dependents. We've done all that. No dependents. Just two nominees. One has already passed away. And
the one, so sorry, Tisha, the one died before the deceased, correct? The deceased member.
Yes, but yeah. So the
Yeah.
deceased did not update their beneficiary nomination.
Okay, so look, if that nominee, then basically I think the nominee would then receive whatever the second nominee, so say 50% the benefit, and then the balance would be paid into the estate of the member, because there are no dependents.
Okay, and that is the rule. Is it a written rule, or where can I find that in writing?
If you look at the scheme of Section 37C, I think if
Yes.
you look at the scheme of Section 37C, that will become evident.
Okay, I'll check.
Okay.
Yeah.
You're welcome. Okay. Are there any other hands?
I don't see any other hands, Zareena.
Oh, I see another hand.
Belele, I am going to allow your mic. If you can unmute yourself, please.
Thank you for that. Thank you, Zareena, for the presentation. Quite lovely. My question is also on the chat side. I thought let me raise it because I think I'm not the only one who's raised a similar question. We spoke of a guardian to minor children. What if, for instance, at the time, for instance, of a decision, the guardian ticks all the boxes, seems to be the correct person, they are responsible and everything, but then human beings are human beings. You find out, I think there was a case at some point, so you find out years down the line that actually the minors never knew that their parent had left them money, and that money was entrusted to this particular guardian. So what recourse do the minors have? Does the board have any action legally that it can take, and where is that based on? Thanks.
Okay, but thank you for that question. What it does, I mean, it does beg the question though. One would assume that that money was used for the daily expenses, for the needs of the child, whilst growing up. So remember that the child would have to be fed, clothed. The child gets to live under the roof of the guardian. So I mean, have all those factors been taken into account? If it is that there is an abuse, that may be perceived, then of course that child, when the child reaches majority, could have a legal, may take legal action against the guardian. But it is a complicated one because in respect of what will you take that action? You'll have to show that the monies that were given to, or that was meant to be spent on you as a child, was in fact not spent on you. But you see, the challenging part is that you're actually in that, I would assume, you're in the guardian's home. That's why you're the guardian. As I said, there are so many running expenses. Could you then really say that that money wasn't spent on you? As I said, look, it's complicated and it depends on the facts of each case. But if it is that you're saying, there's obviously the human factor, maybe there was abuse. As I said, the member or the child is not without recourse in that instance.
No, thank you for that. Without belaboring the point, I'm glad that you've covered the extreme side of that case, but it's, to my understanding, there was a case that I came across. It was actually that extreme where children grew up, struggling, and never actually grew up not being looked after at all, and in fact were at tertiary and were struggling to actually even keep up with schooling and everything. So no money or little money was ever spent on them, but it was totally misappropriated by the guardian. But if you're saying that there's nothing the board can do in that instance, but it's basically the minors' duty to then take it up once they are of age legally, then no, I understand. Thank you.
Zareena, Estelle's hand is up.
So much.
Sanja?
Yes, Estelle, I've allowed your mic. If you could please unmute yourself. Estelle, if you could please unmute yourself. I think Estelle might be struggling with her unmute. Hi, Estelle. Oh, okay, Estelle has put her hand down. So this brings us to the end of this session. Thank you so
Sorry,
much.
Sanja?
Yes, Tando?
So, sorry, I'm sorry, before you close, I'm just hoping that this chat in the chat box will still be available after the meeting, because some of our delegates are interested in the authority that we rely on when we say there's a presumption of paternity. When a person was with the deceased just after he died, before he died, sorry. So I've undertaken to send them the authority. It's in the law of evidence, and it's in the Hitton and Cronje family law. But I'll send them the authority that we rely on for that proposition. So I'm just hoping that all their emails will still be kept in the chat box after we adjourn.
It will
Thank
still
you.
be kept, Tando.
Hi.
Yes, the chat box
Okay.
will still be kept.
Sorry,
Okay,
Sanja,
super.
I and Tando and sorry, and the attendees, my apologies. Load shedding hit me, and sorry, and that's why I went off, but I'm back on. I think is it Sipilili? Sorry, I'm probably butchering the name. I'm so sorry, but I think he was still saying that we were on, and I don't know, Tando, if you managed to answer or the gentleman who said that, he has had that experience where the children went to varsity, and, that it actually turned out that the parents had left, probably quite a considerable amount, but that money was not utilized for purposes. As I said, it will depend on the facts of the matter, but that major child will then be able to have recourse. But I see there's another hand, Tando, if I think, is it Estelle?
It's Estelle already, yes? Could you unmute her, please, Sanja?
I have enabled her mic. Estelle, if you could please unmute yourself. I'm not sure. I think Estelle might be struggling with her unmute. So perhaps if she can pop her question in the chat box, because I have enabled her mic, but it's not unmuting.
I think Estelle wanted to discuss the matter of approved and unapproved benefits, and I think there's somewhere in the chat where she says if the policy is owned by the fund, then it's approved. If it's owned by the employer, then it's unapproved. I think she was trying to explain that whether if premiums are tax deductible, it is definitely an unapproved. I think that's what she wanted to elaborate on, because that's her comment on the comment section section. Sorry.
Okay, no, then thank you for that comment, Tando. I do see another hand.
It's your hand, Zareena.
Oh, my apologies.
It's okay. So
Sorry.
that was the last hand. I see Estelle says she's unable to unmute herself. She's
Okay.
struggling. So I think we should move to the next presentation, because we will be there will be a question bank, and we will be taking all the questions in the chat box as well and putting it into the question bank, and that will be distributed to all the attendees and be put on our website as well. So if we can go to thank you, Zareena and Tando, so much for this session.
No, you're
It was
most welcome.
It was a really interesting
Sancha, I just wanted to respond to one question that I saw in the chat, if I may. I think do we still have 3 minutes, or are we over time?
We have 3 minutes, yes.
Okay, so I saw a question in the chat where someone said that where the mother's married to someone else, right? The mother's now married someone else. And the question then becomes, can that mother who's married to someone else then receive the or challenge a benefit being paid into, say, a beneficiary fund? And so the short answer is that that the mother may be able to challenge it. I mean, she could do so on the basis of saying that, you know what, why is it because I've married someone else that you think I'm not able to take care of, you know, either of the child, of the money, etc. I see Estella's hand is up again. Sancha, I don't know if you just want to try her again.
She is enabled, but I think she's struggling with her mic. Yeah, she's not able to unmute.
And is that the
herself.
only hand? Because I see Simon's hand is also up, Simon Cocken. So maybe shall we just take Simon?
I don't see Simon's hand on my side. It's only Estelle.
Okay, on that note, then thank you very much. I seem to see Simon, but I don't know how to enable. I don't know if I have the power to enable him. So on that note, thank you very much. And as the colleagues have said, if you have any questions, please, or at least the questions that you have asked, we will consolidate it and send it to yourselves together with the presentation. Thanks so much for your time.
Thank you, Zareena, and thank you for the presentation and for attending to all the questions, as well as Tando. We will move to the next session now. The next module is on surplus, and it will be presented by Karabo Mofomme, who is the manager of our actuarial department, and he will be moderated by Daniel Nowack.
Sancha, sorry, just before Karabo comes in, I apologize, man, for coming in like this. There was a request in the chat box for a 10-minute break. I don't know at what point, but one of the delegates had asked perhaps if we could take a breather of 10 minutes. You will decide as to when that is appropriate. Thank you.
Yes, I will just check if we have enough time, but I'm hoping to do it before investments.
Thanks, Sancha.
If that's okay. Okay, thank you, Tando. And I hand over to Karabo.
Good morning, everybody. Thank you, Sancha, Tando, and Zareena for the previous presentation. I think it was quite an interesting one. I also had my own personal questions, but I could see everybody was quite participative when it comes to that session. Let me try to share my screen. Okay, please let me know if you can see my screen on my side.
We can see the screen,
We
Karabo.
can see the screen, Karabo.
Okay,
yes.
perfect. Thank you so much. There's so many screens opened up, but okay. So let me disable this. Okay, there we go. Okay, as Sancha has mentioned, my name is Karabo Mofomme. I work within the Actuarial Services Department. And for this session, I will be speaking on surplus, meaning who owns surplus, what is surplus, the surplus apportionment scheme, the employer surplus account, member surplus account, and the apportionment, whether of future surplus as well. Maybe not in the same hierarchy that I just mentioned now, but that's the main discussion that I will have with you guys. My presentation will definitely be short enough so that you can have that lovely break that was suggested earlier on. So if you can bear with me on that. Okay. So firstly, what is surplus and actually who owns the surplus? So from a graphical representation, whenever a valuator values a fund, they will look at the assets compared to the liabilities and reserves that the fund actually have. So then the surplus in a fund will actually be the amount of money that is not earmarked for any specific purpose. So in this graphical representation, if we would say that the assets of the fund is just 100 Rand and the liabilities as valued by the valuator is 70 Rand, and the reserves that are required or seen as necessary is just 20 Rand, then the remaining amount of 10 Rand will definitely be the surplus of the fund at the point in which the fund has been valued, so the valuation date of the fund. So now this remaining pot of money does not necessarily belong to any particular stakeholder. The board of the fund can make a decision on what to do with this money, whether to allocate it to members, increase the reserve accounts, do whatever they see fit with the money. So fundamentally, this is how you would determine what surplus actually is, and that it doesn't necessarily belong to any stakeholder. It belongs to the fund, and the board of the fund can make a decision on how this can be apportioned. Now, just to get a bit of history before we talk about the surplus apportionment scheme. Historically, the Act did not necessarily explicitly state how a fund needs to deal with surplus, who should get it, and how the consideration that goes into it. So it wasn't explicit within legislation. Each fund could deal with it as it sees fit, looking at its financial history and so on. Now, with surplus legislation being introduced in 2001, this is when the principles and rules around surplus and how to deal with it was actually introduced. So the effect that the surplus legislation had at the time was, one, a fund had to do a surplus apportionment exercise, which was at the surplus apportionment date, which is the first valuation that is done following the enactment of the Act. And the fund had to do an investigation on, does the fund have surplus at that point in time, including any historical improper use of surplus. So the total surplus will be combined, and then the fund will do that apportionment. And then in addition to that, the Act at the time then introduced minimum benefits. And I think it was presented on Tuesday about what minimum benefits relate to. And in addition to that, the Act also outlined principles that the Board of Trustees can follow when apportioning any future surplus. So future surplus, obviously, I'll deal with it in later slides, but it relates to surplus that actually arises following the surplus apportionment date. Now, to come to what is the surplus apportionment scheme. So as I noted previously, after the surplus legislation was enacted, each fund that existed at the time, so any fund that commenced prior to 7 March 2002 had to actually perform a surplus apportionment exercise. And this actually entailed, one, the board had to investigate if the fund actually has surplus at that point in time. And if they do have surplus, then they had to go back and apportion the surplus to exited members, pensioners, and all other stakeholders at that point in time. Now, the surplus at the time, it was the normal surplus that is noted in the valuation report at the surplus apportionment date, including the improper use of surplus. So improper use of surplus is actually the when the fund actually investigate how historically the surplus had been utilized by the fund. The Act actually is more prescriptive of the instances where those utilization of surplus is considered to be improper. And if a fund discovers that they did use surplus improperly, this money will be refunded, must be refunded into the fund by the employer. And then the combination of the surplus that has been valued by the valuator and the improper use of surplus is the total surplus that will be apportioned. And within Section 15B, the Act actually gives down the rules on how this total surplus can be apportioned between the various stakeholders. And then once the fund has decided on how to apportion this within the rules that the Act prescribes, the scheme of how the apportionment will be done will be submitted to the regulator, and then we will approve it, and then the fund can actually implement the scheme as approved by the regulator. Now, within the scheme, how it is drafted, the hierarchy on which people that take more preference would be firstly the former members, and these are members that actually left the fund before the surplus apportionment date, but they did not get their minimum benefit. So at that point, the fund has to first ensure that they top up or they allocate sufficient monies as far as the surplus in the fund is sufficient to meet their minimum benefit, and also consider the pensioners should the pensioners not have received their minimum pension increases as well. And After the apportionment to these two categories of stakeholder, the fund has monies remaining that will be referred to as the residual surplus. Then the board of the fund can then decide who will now receive a portion of those monies. So it will still, the board can still consider the former members and pensioners, as well as active members and the employer as well. They can be considered in the residual surplus distribution. Now, when it comes to future surplus, as I noted earlier on, this relates to surplus that arises within a fund following the surplus apportionment date. There is an array of reasons how a surplus can come about in a fund, particularly in a DB fund. However, even a DC fund can actually generate surplus from its normal operations. Now, the board of the fund, when they have to think of how to apportion these monies, the Act actually, 15C actually kind of gives some high level principles, if I can call it that the board can take into account. So one of the principles is that the board can formally amend its rules so that the thinking behind how surplus will be apportioned is embedded in the rules, or they can leave it open-ended so that it can be decided on as and when the surplus arises, so that they can take into account the source of the monies and how it arose and which stakeholders contribute towards the surplus and so on and so on. So they can leave it open or can amend the rules so that it is more solidified in the rules on what who will benefit or who will receive a portion of the surplus should it arise in following the surplus apportionment date. Now, when the rules or at any point when the board decides to allocate the surplus, they need to take into account the interest of all stakeholders. That's the principle that is included within section 15C. So the interest would be that is it fair, is it reasonable to give it to a specific stakeholder? Did they, and also when you take into account the interest of them, you also consider the sources of the surplus. So where does the surplus come from? So for example, if a normal DC fund, there are mismatches within the fund and it has sufficient surplus to make another apportionment. Should the fund decide to give it to the employer, then it will be questionable on why is it considered reasonable and fair, and given that the money did not, the employer is not carrying much risk within the fund, and the monies did not arise from some form of fund experience where the employer also had to kind of carry some form of risk. So whenever the apportionment of surplus arises, it is quite important to also take into account the history of how it actually arose. Now, as part of the surplus apportionment to the various stakeholder future surplus apportionment, the fund can establish the employer surplus account and the member surplus account in which they can actually allocate the monies in these accounts. The Act also does allow for the direct allocation of future surplus to members' benefit, not necessarily using this account as a conduit for those benefit improvement or benefit payments. But that being said, the Act has actually explicitly defined these two accounts. And for the member surplus account, it is quite explicit that the monies that has been allocated in this account is just should be used to improve member benefits, firstly, for existing member benefits, to improve the pay benefit due to former members that exited after the surplus apportionment date. It's also quite important just to distinguish the former members that it is members that left the fund, but following the surplus apportionment date of the fund. Monies in this account can also be used to reduce the contributions due from members and expenses that would have impacted active or existing members' retirement savings. And as noted, that this account, the member elected trustees are the ones that can vote or make decisions on how to use monies in this particular account. Now, similarly to the employer surplus account, the employee elected trustees are the one that can make decisions on how to use monies in this particular account. So the monies in this account can be used for a variety of reasons, and these are also outlined in Section 15E. 1, subsection 1 of the Pension Funds Act. This entails a contribution holiday that the employer seeks to enjoy, post-retirement medical aid subsidies, covering fund expenses that are supposed to be paid by the employer, and they can transfer monies in this account from one fund to another. However, the employer has to be the same on the two funds that the transfer happens, and the transfer needs to be approved by the regulator as well in terms of Section 15E subsection 2. Also, the employer can use the monies in this account just to improve benefit of members or a specific category of members to avoid retrenchment as well. If at SAD there has been improper use of surplus that needs to be paid into the fund by the employer, and there is monies allocated in the employer surplus account, the employer can use this money to actually pay the debt payable to the fund by the employer. And obviously upon liquidation, in terms of Section 15I, then the monies remaining in the employer surplus account can actually be paid to the employer. And as noted earlier on, this account is actually, the employee elected trustees can actually use monies allocated to this account. So this would cover all the accounts that the Act actually has prescribed to say these are the accounts that the fund can actually use to kind of house and ring-fence surplus, future surplus that has been allocated between members and the employer. So I think that's it on my side. This, as I said, will be quick, short, and to the point. I hope I wasn't too quick for everybody else. Okay. We can take questions if there are any.
Thank you, Karabo.
Sorry, Karabo, there's a question in the chat box. I wonder if Daniel has noted it.
I've noted it. Let me just read it to you, Karabo, and in answering the question, you can maybe distinguish between future surplus and surplus as at SAD. So the question from Mark is,
Okay.
are the deceased members during the applicable period entitled to a surplus apportionment?
Okay, yes, I think before answering that one, it's quite important to understand which surplus apportionment we would be referring to. If it is future surplus, at the point in which the surplus actually arises, the fund or the board will make a decision on who should actually get the monies. So if at a point in time, now just referring to future surplus, at a point in time by the evaluation date, generally, the board decides to allocate surplus to a specific category of people. Once the allocation has been made and the member dies following that day, then the money is still due to that specific category of member within the fund. In a situation where the apportionment of that surplus happened and then the member died before that date in which the decision was made or the effective date in which the surplus has been apportioned, I don't see any requirement that it compels the board to actually also include that particular member in the distribution of the surplus. Now, thinking about the surplus at the surplus apportionment date, should it at that surplus apportionment date, if the former member had already died at the point in which the surplus is being distributed, that particular former member will not be included in the apportionment of surplus. That has been a principle that was taken by the regulators, and it is founded from a opinion that we also received. I just forgot the reference to the opinion that we received when it comes to that particular decision, but that's the principle that has been applied across the board on all surplus apportionment schemes. I hope that clarifies the question or gives direction.
Thanks, Karabo. Mark, do you have any follow-up questions? Are you happy with that answer? In the meantime, I see that someone has asked for the presentation to be shared afterwards. I'm sure that we can do that. Karabo, do you have any
Yes.
issues with that?
No, I don't have any issues with that. I will send it to Sancha and team, and they when they consolidate all the presentation and question, whenever they will distribute to everybody, they can include this presentation as well.
Okay, thank you. Then I'll continue with the questions. Sheila Shankar is asking about future surplus. Can you only distribute to active members, or must the distribution be at all members at the date of distribution? Karabo, can you answer that question for us, please?
Okay. The distribution of future surplus is not limited to active members, and the board of the fund needs to take into account how the surplus actually accrued or accumulated in the fund. So should it happen that the source of the money happened in 2008 because of maybe various, maybe delays in actually maybe doing the report or data issues, whatever the fund might be experiencing, the reporting on that surplus only happened now in 2020, 2021, the fund can still consider members that left the fund because they contributed towards the surplus. It seems more reasonable and fair to also include those members that left the fund to receive a portion of it. However, the decision to also allocate it to those members has a cost attached to it, because if members have left the fund a while back, it might not always be as easy to trace and pay those particular members. So the fund will have to just take that into account as well. However, the short story or the short answer would be that it's not limited to active members.
Thank you very much, Karabo. Then we'll continue with the questions. Nomonde is asking, in bargaining council funds, who decides on the surplus?
The trustees, the board of the fund, they are the one that will still make a decision on who will get monies however they see fit, given the history of that particular fund.
Thanks, Karabo. So Sheila also asked a follow-up question. So she's just mentioning whether or not exited members are also included. I think you did answer the question. So not just active members. Mark says, thanks for the answer. On deceased members, that applies to all exits, I take it. So that's his question. Does it apply to all exits?
Is that the question about whether or not members can receive a portion of the surplus, right?
The question was about whether or not deceased members during the applicable period are entitled to surplus.
Yes, I'll say yes.
Okay, thank you, Karabo. I can't see any further questions on the chat box, and I don't see any hands up. Are there any further questions? Oh, I see one is popping in here from Bongani Ndlovu. He's asking about the event of their deaths. This includes beneficiaries.
So if there is surplus that was apportioned to a former member that subsequently died, and the board saw it fit to apportion the money to that particular stakeholder, it will form part of that member's estate of sorts of it's still a benefit payable by the fund to the member. And I think it will just, I will probably be corrected by Zareena to say that it will probably form within the spectrum of the benefits that the fund needs to pay to that particular member. If they are no longer in existence, the board of trustees will have to figure out who are the beneficiaries to that particular former member, and they will then make a decision on how to apportion or distribute that monies that is allocated to that particular person.
Thank you, Karabo. Zareena, since your name was mentioned, would you like to add on to that answer? Sorry to put you on the spot there.
No, not at all, Daniel, but I must be honest, I wasn't really following. So let me just go through. If the questions are in the chat, let me look at it and I'll respond. Sorry
Okay.
about
No,
that.
no problem. Sorry for putting you on the spot. Then I do see that there's a hand up from Amon Mosekwa. Sancha, can you please unmute Amon's mic and then we can possibly hear his question? Thanks.
I've enabled your mic. If you can please unmute yourself.
Thank you very much, colleagues. Good morning. Thank you, Karabo, for the wonderful presentation. What I wanted to find out basically with regards to deceased members that passed on after the surplus apportionment date. Do the fund has to follow Section 37C for the distribution of that surplus or not? Thank you.
To be quite honest with you, I am not 100% sure if they have to follow the same process, but it seems more practical to actually do. I will probably think maybe the legal department might actually be able to answer whether or not they have to follow the same process or there's another sub-legislation that governs it differently. But to me, it makes sense to actually follow the same process. Tando?
Thanks, Carol. If you remember, Zareena said what comprises a benefit is a death benefit is the fund credit of the member plus the insured portion. So the surplus would it follows logically that it will be part of the fund credit.
Yes.
Because the insured portion is an insurance payout basically. So what I think would pose a problem is when the distribution has already been finalized and the file has been closed. I would assume that the logical thing to do would be to allocate to the beneficiaries as previously identified in proportions that the trustees at that time would deem fit, or follow the same allocations that they did with the first tranche of allocation. I think that would be the logical thing to do. Thanks, Karabo.
Thank you so much, Tando, for that. It seems also my thinking aligned to how Tando's response actually was. But I think that should answer your question, Amon, unless there's a follow-up to that. Okay, excellent. Daniel, is there any other question? Or maybe let me stop sharing so that I can see the questions as well.
I can't see any further questions. Thank you, Amon. If no question comes up in the next 5 to 10 seconds, then I think we can end this presentation and hand over to Sancha. So do we have any last takers, any last questions? Let me just look at the chat. Oh, I do see a question in the chat box. Greg Baykirch is asking, the fund often only becomes aware of deaths years after the death, sometimes 10 years. So I think that's just an additional comment to the previous question. Or I can't, is there a question attached to that, Greg? Maybe you can clarify there. But apart from that, I don't see any further questions. Sancha, back to you.
I don't see any further questions either, Daniel. Amon is saying thank you for the answer. May I request we take the discussion further offline? And if Karabo is amenable to that.
I'm happy to do that. Thank you.
Okay, now then that's perfect. Thank you so much, Karabo and Daniel, for this presentation. And thank you so much to everyone who is still on the line with us. There was a request to take a break. So I think we can do that now. If everyone can be back by 11, then we can start with investments at around 11, if that is okay. Zareena?
That is in order with me. I just also typed in my answer because I finally, I got to see the questions. But I think what we will do, not to confuse the attendees, I think let's consolidate the Q&As afterwards, Sancha, and maybe just have a uniform response,
Yeah, perfect.
to some of the questions. Thank you. And yeah, I'd appreciate the break too. Thanks.
Okay, thank you so much. We will take that break now and reconvene in about, I think it's 12 minutes. So I will see everyone back here at 11. Thank you. Okay, it is 11 a.m., so I think we should proceed. Good morning, everyone, and welcome back to our last Trustee Training Toolkit workshop. Can I just please get a reaction to see if people are back yet? Any reaction? Oh, there we go. Okay, yes, people are back. I see a couple of hands. Yeah, I think we can proceed. Thank you so much. Without further ado, I'm going to hand over to the next and last presenter, Vhutshilo Ramanugu. She will be presenting on investments, which is a very important module, especially with all the new, with all the changes that are coming through, and she will be moderated by Kgaka. So Vhutshilo, I will hand over to you and I will share your slides for you. Thank you.
Oh, there's a hand already. Thank you, Sancha. I'm just waiting for Sancha to share my slides.
Yes.
She will be assisting. Yeah.
Sorry, Vhutshilo. Sorry, just hold on. Yes. Just let me know if you can see.
Yeah, I can see it from my side.
Okay, that's perfect then.
Oh, yes, I do see some hands to confirm. My name is Vhutshilo. Good afternoon, everyone. Thank you, Sancha. My colleagues have shared with you an overview on how a retirement fund is and also how the processes in the fund are executed, including the flow of money within the fund through the contributions. So I'm going to take you through the how the contributions from the members are invested for the benefit of the members. Thank you. You can take it up a bit, Sancha. The first slide after the introduction. No, up there. To step up.
Hi, Vhutshilo, sorry, is this the correct
I think
slide?
it's, yeah. No, I think it's slide number 3.
3.
Just
Okay.
click there, the first, yes.
So this one,
According to the
it?
document. Yes, I can see it. Thank you, Sancha. I'm going to be presenting module number 5, which is investments. My presentation will cover the types of investments and asset classes, investment policy statement and investment mandates, individual investment choice and default investment, investment advice and due diligence, asset spreading requirements. Next slide, please. I will also cover the ESG considerations in investment, the difference between active investing and passive investing, and last one will be the investment return. Next one, please. The assets of the retirement funds are administered for the main purpose of providing benefits to members in terms of the rules of the fund. And a fund has a fiduciary duty to act in the best interest of its members, whose benefits depend on the responsible management of the fund assets. So Regulation 28 provides a list of assets classes that the fund can only invest in, which are your cash deposit, debt instruments, including the Islamic debt instruments, the equities, your immovable property, your commodities. They can also invest in the business of the participating employer, as long as the employer is trading within the borders of South Africa. They can also invest in housing loans to members, which is regulated in terms of Section 19.5 of the Act. And they can also invest in hedge funds and private equity funds and any other assets that I haven't mentioned. Next slide, please. Thank you, Sansha. In terms of Regulation 28, all the registered funds must have an investment policy statement. This is the document that outlines general requirements philosophy, including the policies, the goals, and strategies of the board. The document must be reviewed at least annually by the board, and this must be done together with the financial statements to make sure that it remains appropriate in terms of the members' profile and the needs of the fund. So in terms of Annexure B of Circular PF 130, that provides good governance guidelines, the following is part of minimum information to be included in the investment policy statement. Is the purpose and the scope of the IPS, the essential elements of the IPS, and the risk management, which includes the level of risk attributed to each asset class, and the voting rights. This can be voting rights attached to investments in equities. It also can include the asset manager mandates, which are aligned to the IPS, and any contract that has been agreed upon with the board. It can also include the communication, which includes the monitoring and the reporting on the IPS. Thank you, Sansha. On the other hand, the investment mandate is a set of instruction by the board on how an investment manager may invest assets of the fund. The investment manager in this case is given a mandate by the board and must at all times invest the retirement fund's assets in line with the mandate agreed upon. It is also a requirement that each and every registered fund must have an investment mandate. Thank you. Structure may include both individual investment choice and the default investment. In a case where the fund provides individual member investment choice, the fund must still comply with the limits as set out in Regulation 28. With the default investments, the fund through their boards must include in the IPS provision for one or more default investment portfolios. The portfolios must be appropriate for the members who will be automatically enrolled in the default portfolios. And the composition of the assets and the performance of the default investments must be properly communicated to members in a clear and understandable manner. This includes the fees, the information about the fees and the charges. The default investment portfolio must be priced reasonably and must be competitive in the market. The trustees must consider both passive and active investment as investment options. Loyalty bonuses or other complex fee structures are not permitted in the default investments. And also members cannot be logged into a default investment portfolio, meaning that members are allowed to move from one portfolio to another portfolio within this structure. A default investment must be reviewed by the board. We can go to the next one, Sanchez, thank you. Regulation 32W state that the rules of the fund must provide clearly whether or not the fund's liability to provide benefits to the affected members or beneficiaries is funded exclusively or in part by fund member policies, where the assets of the fund consist exclusively or in part of the fund member policies. Next slide, please. Thank you. A fund must at all times, before making any contractual commitment to invest in a third-party managed assets or any other assets, perform a reasonable due diligence, taking into account the risk relevant to the investments, including the credit market and the liquidity risks, as well as operational risk for assets not listed on an exchange. And for the third-party managed foreign assets or investment in a foreign asset, the fund can perform due diligence considering the risks relevant to the foreign assets, including but not limited to the currency and the country risks. So in performing the due diligence, a fund may take into account the credit ratings, but such credit ratings should not be relied on in isolation for risk assessment or any analysis of the assets. As mentioned on my first slide, a fund has a fiduciary duty to act in the best interest of its members, whose benefits depend on the reasonable management of the assets. So in investing the assets of the fund, a fund must at all times comply with the limits as set out in column number 2 of annexure to the regulation 28. Next, please. The fund may invest up to 100% in cash deposits and also 100% in debt instruments, including your Islamic debt instruments, but only if issued or guaranteed by the Republic. And in any other case, it should be limited to 75%. With equities, the fund can invest up to 75%, and the immovable property is up to 25%. The limit for commodities is 10%, and housing, an investment in business of the participating employer is up to 5%, as long as that participating employer is trading within the borders of the Republic. They can also invest in the housing loans to members, which is regulated in terms of Section 19(5) of the Act. They can invest up to 95% for now. The limit is going to change next year, early next year, to 65%. This is in terms of the National Treasury final amendment to Regulation 28. It has been published on the 1st of July, 2022. But the effective date is January next year on the 3rd. So with the hedge funds, the fund can invest up to 10%. And private equity is also one of the class of assets that has been affected by the change. So at the moment, you can invest up to 10%, but next year it's moving to up to 15%. Any other asset, you can invest up to 2.5%. The consideration of ESG on investments. What is ESG integration? Currently, we don't really have an official agreed upon definition for ESG, but the terms are mostly understood as the integration of environmental, social, and corporate governance considerations into investment management processes and ownership practices, in the belief that these factors can impact the financial performance. So ESG concepts are very important for pension funds and other institutional investors in South Africa and globally. So it is very important that when investing the assets of the fund, the board give appropriate consideration to any factor which may materially affect the sustainable long-term performance of the fund's assets, including the ESG factors. So sustainability is further defined in the FSCA Guidance Notice 1 of 2019 as the ability of an entity to conduct its business in a manner that primarily meets existing needs without compromising the ability of future generations to meet their needs. So for deeper understanding, I urge the trustees to go and familiarize themselves with the practice note, and they can also source information regarding the ESG integration anywhere else, because this is a very huge topic in South Africa and anywhere around the world. So there are many sources that you can get information regarding the ESG and investments. The core objective of the ESG integration is to act in the best interest of the pension fund members by recognizing that ESG factors can create investment opportunities and risks, and must therefore be considered in all investment decisions by the fund. Thank you, Asensha. Going down to difference between the active and the passive investing. The active investment refers to investment portfolio where the weights of individual securities differ from the market or particular benchmark. It requires frequent buying and selling in a bid to outperform a particular index or benchmark. High fees are expected for outperforming the index or benchmark and for taking on more market risks. The passive investment, on the other hand, refers to investing in portfolio that mirrors and tracks the exact weight of individual securities within a particular index or benchmark as closely as possible. It replicates a particular index or benchmark in order to match its performance. So a pension fund may implement either an active or passive investment management approach, or they can opt for a combination of both. The next slide about investment, Sansha, investment return. Oh, thank you. Investment return measures the efficiency and performance of the fund's investments. And the fund return is defined as follows in terms of the Act. For the assets of the fund, the fund return, it's any income and capital gains and losses and on the assets of the fund. And this is net of your expenses and tax charges. And for any portion of assets of the fund, if the assets are separately identifiable, fund return is income and capital gains and losses and on those assets. And this is also net of your net expenses and the tax charges. And for the assets of the fund, to the extent that those assets consist of long-term policies, which are fund member policies as defined in Part 5 of the regulations under the Long-Term Insurance Act. The fund return is the growth rate applicable to those policies as determined in accordance with those regulations. So in any case, the fund return may be positive or negative, or it can be zero. Next slide. The following formula can be used to calculate the investment returns. R equals to 2I divided by A plus B minus I in bracket, where the R denotes the return on investments and the A initial value of investments and the B the end value of the investments, and I being the total income, which includes your interest, dividends, rent, policy income, net profit and losses on realization of investments, and the amount by which investments were returned up or down to fair value. Thank you. That will be the end of my presentation. I thought there was something, there was another slide coming. The floor is now open for questions. Thank you.
Thank you,
Thanks so much,
Vhutshilo.
Vhutshilo. Hi, Kgame, yes.
Yeah, I only got one question on the chat box and I've responded to it. So the floor is open for any other questions that may be raised.
So if there are any questions, please raise your hand and I will enable your mic. Okay, there's a hand. Oh, Zareena.
Yes.
Zareena?
Yeah, Kgame, maybe just share the question with, since there doesn't appear to be any other hands, maybe share the questions in the chat and the responses there too. Thank you.
All right. The question related to the housing loan. They wanted to know that whether this the 95% limit, is it relating to individual member credit? And remember, in instances where members have individual investment choices, we always need to ensure that the limits are adhered to in all instances. So yes, the 95% applies for individuals as well, but then it's going to be 65% in terms of the amendments to Regulation 28 in January next year.
Thank you so much for that response, Kgame. It's a little worrying because Nomonde says there are 3 hands up, but I'm not able to see these. Can you perhaps see them, Kgame or Zareena?
I'm also looking, I can't see any hands.
Nor can I, Sancha. Maybe we can just ask Nomondi to tell us whose hands are up and then take it from there.
Nomonde, if you could put your hand up. Oh, I have a hand. There we go. I'm one. I am going to allow your mic. If you could please unmute yourself.
Thank you very much, trustees. Thank you, Vhutshilo, for the presentation. My question is, let's say for argument's sake, you are a trustee, but you don't sit as a trustee, you don't sit in the investment committee. And then for some reason, you wouldn't have any powers maybe to advise the investment committee in terms of the investment statement policy. So my question now is that what's happening is most of the industrial funds, they've got some form of like collective investment. The members of the fund, they don't basically have any investment options. How do you get that to raise that point to the investment committee if you don't sit in that investment committee, but you are a trustee for maybe for X fund? Thank you very much.
Thank you for the question. My response would be, I mean, as a trustee, all trustees needs to be, knowledgeable of what is their investment policy statement and what it includes, what it incorporates, what is the fund's, investment philosophy and all that. So if there is training required, to be provided, it should be provided for every trustee to be able to understand that. But then at the same time, once a board has decided on an investment choice for the fund to say these are, the portfolios that they can be chosen in terms of the philosophy and member profile of the fund. Those choices, the members would then have to look at them. But then remember, in instances of collective investment schemes, as long as they are Regulation 28 compliant, we had the exclusion up to now to say the look-through doesn't get provided. So we don't get to see what the underlying assets are, but there must be confirmation relating to compliance with Regulation 28. So the actual look-through would not be provided, but then there must be a certificate that is obtained to indicate that the specific collective investment scheme is in compliance with Regulation 28 requirements. I don't know if that answers you.
Yes, it does answers me. Thank you very much. But I think maybe Zareena has got some more input on that regard. Thank you.
Yes.
Zareena?
Thank you, Kgame. Thank you, Amon. Yes, so Amon, even if you have your subcommittees within the fund, it doesn't divest the board of its and the trustees of its responsibility in respect of the fund. So, if there are any concerns surrounding the mandates or investments, as a board member, Amon, and colleagues, you still have that duty. You're not divested of that duty. So if you see that anything is remiss, or you want to provide input, it doesn't matter that you don't sit on that subcommittee. It's similar to a big death benefit subcommittee. I think strictly speaking, you aren't simply, supposed to put up your hands and say, but that's what the death benefit subcommittee decided. There's nothing I can do about it. Of course, as a trustee and as the board, you still have that overall responsibility to the board. If you have regard to your Section 7C, section of the object of the board, Section 7D, your duties, the duties of the board, the trustees of the board. So Amon, that is what I wanted to add. I think that is quite critical, but I do see other hands, Kgame.
Thank you so much, Zareena and Kgame. Amon, I hope you are covered. I have enabled Alistair's mic. Alistair, if you could please unmute yourself. Hi, Alistair, could you please unmute yourself? I think Alistair might be struggling. So Patrick, I've enabled your mic. If you could please unmute yourself.
This is Alistair speaking. I did not put my hand up, so I'm not sure how that indicated. So I don't have a question. Thank you.
Okay, thank you so much, Alistair. Okay, Patrick, if you would like to pose your question, I've enabled your mic. I don't see any more hands. So I think we can end the session if that is okay.
Sancha, if I may just again come in here and just extend a word of thanks to all the trustees who have attended these sessions. I know it's day 4, so it's been quite rigorous, you know, and it's been, you know, having people put aside quite a few days to attend these sessions. We hope that you found it useful and informative. And thank you very much for staying with us for the long haul, these 4 days. And and I would also like to express my thanks to the presenters, the moderators who have, you know, obviously used much of their valuable time to actually put together the presentations, to ask very poignant questions. And thank you very much for a very interactive session or interactive sessions during the course of this this morning. And yeah, may you have a blessed rest of the week. And I hope that this will really put you, you know, on a good path to really doing the Trustee Toolkit training and you know, doing very well in it. So best of luck, and best of luck in exercising your fiduciary duties in the best interest of members. Thank you very much. Bye-bye.